a deeper dive into the revised federal nursing home regulations. This is Lori Smetanka, and I'm the Executive Director of the National Consumer Voice for Quality Long-Term Care. We're delighted you could join us today. This is the third in a series of webinars covering sections of the revised federal nursing home regulations that were issued in the fall of last year. And we have been wanting to, as the title suggests, take deeper dives into different sections of the regulations, since this is the first time in 25 years, as you know, that the regulations have been revised to this extent. We've talked in the past, and you've not only on these webinars, but you've also seen, I think, email messages from our different organizations that these regulations not only had been revised and passed, but that there was some concern that they would be rolled back, since the timing of when they were issued in the fall of last year made them subject to potential rollback under the Congressional Review Act. We just wanted to update you on that by letting you know that the time frame within which a resolution needed to have been introduced to roll them back has now passed. That needed to have been introduced by March 30th if there were going to be attempts to roll these regulations back. That has passed, and so these regulations now will stay in effect moving forward. So we are pleased to announce that, in the sense that we're able to talk about them and understand that we are confident in the fact that we'll be moving forward with the language that we have with us from the regulations at this point. So for today's presentations, we are going to be reviewing the sections related to bed hold and return to the facility, which is going to be covered by Eric Carlson, the directing attorney from Justice and Aging. We'll also be covering the sections on grievances and resident and family councils, which I will go over, and also we'll be covering the sections related to quality of care, covered by Toby Edelman, who is the Senior Policy Attorney at the Center for Medicare Advocacy. Following the presentations, we will have questions and answers, and as in past webinars, you can type your questions into the question box on your webinar control panel. We will cover as many of them as we can in the time allotted, but because of the large number of attendees, all lines will be muted throughout the webinar, and as you heard at the beginning of the broadcast, the webinar is being recorded. This webinar, and there are issue briefs corresponding to the topics that we are covering today, will be posted to the Consumer Voices website following and can be downloaded from there. You can also see some of the handouts, the PowerPoint and the briefs in your webinar control panel under handouts. You can download them from there as well. And don't forget that the previous webinars and briefs that we've covered in the past webinars are also available for download from the Consumer Voice website. Next slide, please, Alicia. As a reminder, the regulations are being implemented in 3 phases. Phase 1 went into effect last November and included the vast majority of the regulatory sections, particularly the existing requirements that were maintained through the revision. Phase 2 goes into effect November 28th of this year. And you'll see on the slide, which we've showed you before, what some of those sections include. And then there is a third phase that will go into effect in November of 2019. As of today, CMS is still on track with this implementation schedule, so we are expecting the next set of sections to go into effect in November, and CMS is currently working on revising the interpretive guidelines that go along with these regulations. They are expecting to release those this summer, as well as conducting training and introducing a new survey process that will be implemented that covers all of the new regulations. So lots still going on, but for purposes of today, let's get started with our presentations, and we will start with bed holds and return to the facility, and I'll turn it over to Eric Carlson.
Thanks, Laura. We're going to cover, as you saw from the title slide, this covers 2 areas. It covers bed holds and also return to the facility, those are similar concepts, but they're different in part because the source of the law is different. The bed hold law is covered by states, and the return to facility law, it comes from the federal nursing home reform law. The state law generally sets out a couple of things, focusing on bed hold here. There's the length of the potential bed hold, so oftentimes you'll see a state regulation that mandates that a facility offer a bed hold of at least 1 week or 10 days or 20 days. Span of time like that is relatively typical. And then in addition, it'll be the state law that sets the ability of the state Medicaid program to pay for a bed hold. And I think across the board, almost across the board, and for obvious reasons, there's congruency between what Medicaid will pay for and what is available under the state licensing laws. So if, for example, the state requires a facility to offer a bed hold of at least 7 days, Medicaid's going to pay for a 7-day bed hold, or 10 days, or 15, or 20, whatever it is. That's some of the typical provisions of state bed hold laws. State bed holds are not universally available. There's certainly going to be some states where the law doesn't mention it in one way or another. And it's worth mentioning here that even if there's not a specific bed hold provision, it's worth arguing that that the person has a right to hold a bed regardless, particularly in situations, you can imagine a bed hold being negative in some case, limited to 7 days, where otherwise the person, the resident's family member might say instead, hey, it's May 1st, we just paid for the entirety of May. It may be that the resident's in the hospital right now, but he or she certainly should have an obligation to come back, or an ability to come back anytime within that month. So just a note here, I think we oftentimes operate under these bed hold rules thinking that that might be the only way to quote unquote hold a bed, but don't necessarily ignore the argument that the person paid for it, they haven't been evicted in any way, and so they should have a right to come back. And again, particularly applicable to people who are paying out of pocket in advance for particular days. Next slide, please. And then the federal law gets involved in this situation not by setting the particular standards for bed holds, but requiring notice of bed holds. The federal law establishes these notice requirements for hospitalizations or what the federal law calls a therapeutic leave, which is a visit with family members or friends. And then the notice is required at 2 times under the federal law: before the resident leaves. And as a practice, it doesn't say exactly how much before the resident leaves. In a practical matter, you generally see this done by nursing facilities at the time of admission. It's an advanced notification of what the rules are, and so you'll oftentimes see this notification as part of the admission agreement documents. And then secondly, under the federal law, there's also a requirement that there be notice done at the time of transfer. So 2 times: before the resident leaves, which is a practical matter, is usually when the person is admitted to the nursing facility, and then secondly, at the time of transfer, when the resident is in the process of leaving to go probably to a hospital or potentially out to a visit with family or friends, so-called therapeutic leave. Next slide, please. Let's first look at this advance notice. This is the one that's likely going to be given at the time of admission. Here, the federal law requires a significant amount of information. It has to include the relevant state law. That's the state law that I mentioned a couple minutes ago. Do you get a mandatory bed hold availability under the state law, and what's the state Medicaid program willing to pay for to hold a bed empty but regardless available while a person is in a hospital. Second of all, the facility's policies, and as you would imagine, those policies have to be consistent with state law, as to the bed holds, and they also have to be consistent with the federal right to return law, which we'll discuss 3-4 minutes from now. And then also in the federal regulation, there's a requirement. I've quoted the language here because it doesn't make complete sense. It has to include the information specified in paragraph C3, which is the notice of involuntary transfer discharge. So, on the one hand, maybe it'd be helpful requirement that it would list the transfer discharge rules, but on the other hand, C3 is ordinarily noticed given when there's actually an involuntary transfer discharge being proposed by the nursing facility. So it's unclear how in the world that requirement fits in the context of notice, which is being given likely at the time of admission when there's no particular dispute or particular facts at issue. It's just a broad notice as to what the rules are. I could say here in another case in the bed hold regs, it actually appears that it's a mistake. That my guess is that in the process of moving these regulations, they used to be in a different section of the law. There were a lot of moving parts when the regulations were revised, and in this case, in another instance, in these bed hold right to return regulations, the cross-references don't make complete sense. So I mentioned it here, pointed out that there may be something useful in this requirement that you could cite, but also to mention that there may be some mistake in the cross-reference. Don't want to dwell on it, but I do want to point out that it doesn't make complete sense in the context of an advance notice. Next slide, please. So that's the advance notice, and then we move on to the notice at the time of transfer. This is when the resident is about to go to the hospital, for example. And here, the information is more limited. What the regulation says that it has to include the duration of the required bed hold period. So, which makes sense. You, at a minimum, would need that information. I'm, for example, about to be transferred to the hospital, let's say, and the nursing facility would tell me, yes, Mr. Carlson, you have the right to hold, under state licensing regulations, you have the right to hold your bed here for 7 days, for example. The federal regulation is relatively limited here in what it requires. You would hope that the notice would also include the Medicaid information. That would obviously be relevant to tell me not only, Mr. Carlson, 7 days, but also Medicaid will pay for 7 days. And ideally, you would include the other information included in the advance notice as well. For example, whatever rights you may have under federal law to return to the facility regardless of a bed hold. So that's the bed hold. Speaking of return to the facility, let's move on to the next slide and take a look at that. This is a provision where the substance of the law is dictated by federal law. So we're no longer in a situation where the substance is set by state law and the federal law is just about notice. Here, the substantive right is set by federal law, and so that substantive protection applies across the country to all of these facilities that are certified for Medicaid or Medicare or both. This is an additional protection if, let's say, the bed hold period is exceeded. The state gives you 7 days, but you've been in the facility for 10 or 20 or 30 days or 2 months or 5 months. Doesn't matter. There's no outside limit. You would apply if there wasn't a bed hold available under state law to begin with. It would also apply if there was a bed hold, but the person chose not to exercise it. Next slide, please. So you have a right under those situations to return to the facility. Even though you didn't hold a bed, you didn't pay, and I should have mentioned under the bed hold, if you hold the bed in a private pay status, you're paying for it. You're holding the bed by paying for those days, even though you may be in a hospital, for example. If you're Medicaid eligible, the Medicaid program may pay. But so the return to the facility condition on that. There's no bed being held for you, but you nonetheless have a right to return if you continue to need nursing facility care and if you're eligible for payment on return by either Medicaid or Medicare. So notably, the right to return does not apply to people paying privately, but this is better than it was in the previous round of regulations because the Medicare eligibility has been added. So now if you're eligible on return for payment by Medicare or payment by Medicaid or Medicare, the right to return can apply. Next slide, please. As was the case in the previous regulations, this applies to the next available semi-private room. Yep. And it does not require that men and women share rooms. So what's new in this regulation is that the previous room has to be made available to the person if it still is vacant. So if you're right to get into your previous room, and if that's not available, the next semi-private room, as long as moving into that semi-private room doesn't end up requiring that men and women share rooms. It's an advocacy point here. It's very important when this happens that residents and their advocates not be too hung up on getting in immediately. The facility may say, for example, on the first day if the person's trying to return, oh, sorry, we don't have a vacancy. You as a resident or an advocate don't at that point want to just throw up your hand and say, well, that's it, I'm not getting back in, there's nothing to be done. But instead make clear that, okay, the next available will be next available, and I'll be checking tomorrow, and the day after that, and the day after that, and the day after that. So a facility may be willing to say, maybe whether true or not, that there's no vacancy. That becomes harder the longer the person continues to ask for readmission. So it's really a powerful provision. Most facilities will have vacancies, either immediately or certainly eventually. In my experience has been that nursing facilities and others are oftentimes focused on this bed hold right. So it's 7 days, 10 days, and once that period is exceeded, they assume, oh, that's that, nothing, no right to come back in. But this provision is incredibly powerful and useful, and that's even more true now, given that it applies just not only to people who are eligible for Medicaid upon return, but also for persons who are eligible for Medicare-funded nursing facility care upon return. Next slide, please. And this is the final point I want to make on the right to return. There is some good language here that deals with the situation, the unfortunately common situation, where facilities just refuse to let people back in these situations. And it's a difficult position for residents. The residents in the hospital wants to get back in. The facility says, well, no, we've determined we can't meet your needs. In my experience, it's likely not a true allegation. And then the resident is subject to pressure from the hospital saying you can only stay here for another 24 or 48 hours, and finding it difficulty to force himself or herself back in the nursing facility. A lot of people on this call are probably familiar with this problem. There's good language in the regulations now that makes it clear that in these situations, if a facility is refusing to let somebody back in, it's equivalent to an involuntary transfer discharge and should be treated as such, which means, I would contend, and I think the language here supports this contention, that the facility should readmit the person if the facility wants to claim that the person is subject to involuntary transfer discharge, whether for non-payment or for his or her needs supposedly exceeding what the facility can provide. Whatever it is, under any of those six requirements, six standards that are allowed under federal law, the facility's got to readmit the person, allow that person to return rather, and then and then go through the process. And that's much fairer for the residents. You can think of it in a landlord-tenant context, an apartment-tenant context. You can't just evict people like by essentially locking the door once they've gone temporarily. You've got to go through the process. And a nursing facility, just like an apartment landlord, shouldn't be taking advantage of a hospitalization to lock the person out. And the comments here, the regulation and the comments in the Federal Register make that clear. If you look at the slide here, this is new regulatory language saying that if the facility determines that a resident has an expectation of coming back, either under bed hold or under return to facility, the facility is going to have to comply with transfer discharge procedures and not just say we're not taking you back, period, but give the notice, give the person an opportunity to appeal, and not to refuse the person until he or she has an opportunity to go through that appeal process. And then the final slide supports that. This is language from the Federal Register that was released surrounding the regulations. This is CMS commentary in effect on the regulations, and it's here available for you. I think it's something that you may want to cite in these situations. The facility, the CMS recognizing that these are discharges and that people should be able to take advantage of the protections against inappropriate discharge, and the facility has to comply with those transfer discharge requirements of Section 483.15 sub C. So with that, let's move on to talking about grievances, and I'll pass the microphone back over to Lori.
Thanks, Eric. Next slide, please, Alicia. In this section on grievances, CMS added quite a bit of new language and requirements that the facility must follow in order to respond to grievances that are raised by residents. And, you know, we hear a lot of concerns from residents and family members that complaints or grievances that they might have filed previously with the facility would sometimes go off into a black hole, and they wouldn't know what had been done about them. If anything, they would not get any messages back in terms of what had been done or what a resolution might be implemented. And so I think that CMS attempted to address this with some of the revisions and additions that they made to this section. They maintained language that residents have the right to file complaints or grievances without fear of retaliation or discrimination, and that applies to any type of issue that the resident has related to care that's received in a facility or even care that's not received in a facility. They still have the right to file a grievance about that. And that can be certainly with the facility itself, or also in the languages that there needs to be protections that the residents have the right to file grievances with entities that accept complaints even outside the facility. So for example, with the Ombudsman program or with the licensing agency. Complaints can be filed orally, in writing, or anonymously, and protections need to be put into place so that a facility will accept grievances in any of those manners. So however a resident is comfortable raising a grievance, they should be able to do so in whatever way they want. There's a new requirement that a facility must designate a person, a staff person, as a grievance official in the facility. And it's the purpose of this person to ensure that they have responsibility and authority for guaranteeing that grievances are appropriately managed and resolved. So it would make sense that whoever is designated as a grievance official would be connected, or a person in facility leadership like the administrator or the director of nursing, for example. It has to be someone who has the authority to follow up on the grievance, to follow it from beginning to end in terms of receiving the complaints, leading any investigation that takes place, tracking the progress of the investigation, coordinating with any state or federal officials should that occur, and then reporting back to the person that actually raised the grievance or made the complaint with them. But that there needs to be a designated person that residents are told who they are and given their contact information so that should there be a concern or a grievance that they could address it with that person. There's also a right to prompt efforts by the facility to resolve grievances, and residents need to be told what the reasonable expected time frame is within which they should hear back about the concern that they've raised. Prompt efforts is fairly loose and there's no specificity with respect to that. So that's something that should be addressed in a facility grievance policy. And Alicia, if you move to the next slide, we'll talk about that. Because now these regulations require that a facility have a written grievance policy put into place that addresses a number of different provisions as we see on the slide. So certainly there need to be provisions with notifying residents about their rights to file grievances, and that can be done individually. It can be done by putting notices in common areas in the facility, postings throughout. It could be done through written notification, but the facility has to make sure that the resident knows that they have the right to file a grievance and how to do that. They also, as mentioned just a minute ago, need to identify a specific grievance official and make sure that residents know how to contact that person should they have a grievance to file, including address, phone number, however it is that that person can best be contacted. The facility has to provide that information to the residents. The facility policy has to include language that shows that the facility is protecting residents from further violations of rights. Once a grievance about a rights violation has been brought to their attention, they have a responsibility to ensure that further violations of those rights don't continue while the grievance is being addressed and investigated. So that needs to be included in the written facility policy. The policy also needs to include language that assures that any reporting of alleged violations that relate to abuse, neglect, or exploitation are appropriately handled in terms of following facility policy or state law in terms of other reporting requirements. So if there are allegations of abuse, neglect, or exploitation, those grievances need to certainly be provided also to the administrator and to whatever state law requires in terms of the agency that does investigations of abuse, neglect, or exploitation, whether it be the survey agency or law enforcement or whomever that is. But those policies need to be followed. The residents have the right to a written response to their grievance, and certain information needs to be included in that, and I'll cover that in just a minute. But the written grievance policy also needs to assure that if a violation of rights is confirmed through investigation, that corrective action is taken. And that needs to happen whether the confirmation of the violation is confirmed by either the facility itself or by an outside investigation, such as by the ombudsman or the survey agency. But in essence, the facility has a responsibility to assure that they are correcting any violations of rights. The policies require that the facility maintain results of their investigation around the grievance and any information about correcting the grievance for a 3-year period of time. That has to be maintained. It doesn't say how that has to be maintained in the regs, but a facility has a responsibility to do that. And the policies must also assure that the facility does not prohibit or discourage a resident from communicating with any of the agencies or programs outside of the facility that have a responsibility to accept complaints or provide assistance to residents, such as I mentioned, the Ombudsman Program, the licensing agency, protection and advocacy, anything like that. So next slide, please, Alicia. As I mentioned, the facility, the resident has the right to have a written response to a grievance by the facility. So once they have notified the facility of a grievance, they have the right to request a written response, which will include the information that you see up on the slide above. And it's very specific in the regulation. The response has to include the date the grievance was received, a summary statement of the grievance, what the issue was that the resident has raised, what steps the facility took to investigate the grievance. That has to be included, as well as a summary of the findings or conclusions of the concerns that the resident raised with the facility. It has to state whether or not the grievance was substantiated or confirmed. That has to be included, and then any corrective action that the facility is going to take in response to the grievance, and then also the date that the decision was issued to the residents themselves. So this is really a means, I think, of ensuring that there is responsiveness in a timely manner to residents that have raised grievances, to show that they're taken seriously, that steps actually have been taken to investigate the grievance, and that there be some steps to correct whatever the issue is. Now, that doesn't mean that any grievance, maybe the facility needs to do due diligence and take appropriate steps to do good investigation and to respond to the residents to correct whatever grievance it is that they have identified. Next slide, please. So moving on from grievances, there's a little bit of relational information here as we talk about resident and family councils. So there also is information in the regulations about the rights of residents to associate with and form resident groups and family groups within the facility. So the resident does maintain the right to participate in a resident group in the facility, as do family members. They also can organize into a family council. One variation in language in these new regulations is that the right to participate in a family council actually lies with the resident. The resident can determine whether they want their family member to participate. And in explaining this in the preamble language, CMS has indicated that the right of the family certainly stems from the rights of the residents that are in the facility, but also that there may be situations in which a resident might not want a family member, such as someone from whom they're estranged, to participate in a family council. And so the resident certainly then maintains that right. But once the family councils are organized or set up and the resident gives their family member certainly the right to participate, they have the right to do that. And then it's the councils themselves who control who attends the meetings and how the meetings are run. And this has been certainly I think a long-standing provision, but I think there's clarity now in the revised language of the regulations that provides that it is actually the council who controls who attends this meeting, including whether that be staff, visitors, or other guests. They need permission from the members of the council to participate in the meetings of the council. Next slide, please. The facility maintains some responsibilities for supporting council meetings, both resident and family councils. So first of all, there is a responsibility to provide private meeting space for the resident councils and the family councils. With respect to the resident councils, the facility must assign a staff person to assist the council and also to respond to written requests from that group. The council should really determine what kind of assistance the staff person provides. It should not be that the staff person is organizing or running the council unless the council itself asks them to take on a role like that. So, for example, in some councils, they may ask the staff person to send out meeting notices, to reserve a room, to take minutes or notes, but they're and to attend all of the meeting. But then there are other councils that may want to meet independently and ask the staff person to take on a different role, such as just sending out notification about the meeting and not doing anything else. So it's really the council itself that should decide the involvement of that staff person. But they do have to have a person who's assigned to them to also, as I mentioned, to accept any concerns that the council has raised and then to respond to them as well. The facility is required to take steps to make sure that residents and family members are aware of upcoming resident and family council meetings, and they need to work with the councils to determine how that should take place. And the council should have input into that. So it might not be enough that they just post a notice, for example. Can they send out an email notice or send out some other notification or include flyers or whatever it is, but the facility should work with the council in terms of what the best mechanism is for notifying residents and family members of upcoming council meetings. And then there is a responsibility that the facility promptly respond to grievances or recommendations that have been received from the resident or family council. And certainly while prompt is not defined, again here there is a responsibility that the response be done in a prompt fashion, and so the facility should be giving the council an indication of the time frame in which they can expect to receive a response from them. And they need to really show that they have taken into account and taken seriously either the grievances or the recommendations that have been raised by the resident and family council, and demonstrate back in a response to them any rationale for why they will take action or not take action based on that grievance or recommendation that's been made by the facility. That's not to say that, and the regulations state this, that the requirement to act does not mean that the facility has to carry out all of the council's requests, but the facility does need to be able to show and justify why it is taking action or not taking action based on the recommendations or the grievances. So again, it's a means of showing that the facility is being responsive and seriously taking into account the recommendations or the grievances that have been filed by the resident or family council. Next slide, please. So Toby, with that, I'll move it on to you to cover the quality of care issues.
Okay, thank you, Lori. Thanks very much. The federal nursing home reform law that was passed by Congress and signed by President Reagan in 1987 changed everything about nursing homes: the standards of care, called requirements of participation, the survey process, and the enforcement system. And one of the biggest changes was how the law defined the standard of care that facilities must meet in order to be eligible for reimbursement under Medicare or Medicaid or both. The law says that each resident is entitled to receive all of the care and services that the resident needs in order to attain or maintain the highest practicable physical, mental, and psychosocial well-being. There are two key points here. One is that this is an entitlement to high quality of care for each single resident. We're not talking about how facilities do treating residents as a group, but how facilities treat each resident. And secondly, the point is that each resident should function at the highest possible level for that person. We're not expecting people to decline just because they've moved into a nursing facility. CMS interpreted these two key principles of the law in regulations that could be enforced. And the way they did this, I thought at the time 25 years ago, and I still think, was absolutely brilliant. The regulations for quality of care said, if a resident comes into a facility without a particular problem, the person should not develop that problem unless it was medically unavoidable for that individual. And if the person has or develops the problem, the facility should take steps to fix the problem and additional steps to make sure it doesn't happen again. So for example, if a resident didn't have pressure sores on admission, she shouldn't develop them unless there was a medical reason. And if she has pressure sores or develops them while she's living in the facility is supposed to take steps to cure them and try to make sure that the resident doesn't develop them again. This was the essential pattern for many of the subsections discussed in quality of care. With respect to the issue of unavoidability, it's an important point here, A problem is considered unavoidable if the facility develops and follows a care plan for the resident to address the potential or actual problem. But if the facility doesn't follow the care plan, then the administrative law judges who hear facility appeals of deficiencies and remedies, the ALJs will say that the problem was not unavoidable and they will uphold the deficiency. So noncompliance with the care plan means that a particular resident's decline was not unavoidable. The revised requirement of participation for quality of care that was published last fall is significantly changed. There are 14 subsections as before, but they're very different. There's a lot of reorganizing. A couple of sections are identical, but many are revised and additional language is added to those sections. Some subsections are entirely new and some are moved to other requirements of participation. While it may seem a little difficult to search for these requirements, they're in the revised requirements, and everything except one point, one of these subsections at this point, trauma-informed care, which we'll talk about at the end, all of these things are in effect now. Next slide, please. So here are the two provisions that repeat prior language, and they're identical. For vision and hearing, a facility must ensure that the resident receives treatment and assistive devices, and if the resident needs assistance in making appointments or arranging transportation to the practitioners for vision and hearing devices, then the facility has to provide that assistance. With respect to accidents, there are two requirements. One is that the facility must ensure that the environment is free of accident hazards to the extent possible, and the facility must provide adequate supervision and assistance devices to prevent accidents. And this accident provision is one of the most frequently cited deficiencies of all. It covers things like elopements, falls, all kinds of things come under assistance devices and accident hazards. A very important provision. Next slide, please. Now we'll talk about some of the subsections that have language that is both repeated from prior regulations and additional new language. First is skin integrity. For pressure ulcers, the facility is required to assure that the resident receives care that is consistent with professional standards of practice in order to promote healing, prevent infection, and prevent new ulcers from developing. The resident should not develop pressure ulcers unless they were medically unavoidable. This is one provision, maybe the only one, where CMS does not repeat the old language that if the resident did not come in with the problem, the resident shouldn't develop the problem. But it explains in the preamble that it doesn't really think there's much of a difference here because residents still are not supposed to be developing pressure ulcers or having them at admission or afterwards. There's new language on foot care that is part of this subsection on skin integrity. This is brand new, and the requirement is that facility provide care and treatment to maintain a resident's mobility, assist residents in making appointments, and again arranging transportation for medical appointments. Next slide, please. Mobility rules incorporate the old language about range of motion, but again, this subsection is quite a bit broader. As before, the resident should not experience a decline in range of motion unless it was medically unavoidable. But in addition, there is new language that says the resident who has a limited range of motion must receive appropriate treatment and services to increase the range of motion and prevent further decrease in range of motion. Mobility is brand new. This language is new. The resident must receive appropriate services, equipment, and assistance to maintain or improve mobility, and the goal is trying to assure that the resident achieves maximum practicable independence. The new language for foot care under skin integrity and this new language on mobility together, I think, show a new focus on making sure that residents can continue to walk. It's a very important point that residents should not be put in a wheelchair and wheeled around if they're capable of walking. And so CMS is putting new emphasis on this, and we should pay attention to that as well. Next slide, please. Incontinence addresses urinary incontinence, as before, with some additions, and also for the first time addresses fecal incontinence. New language says that if a resident is continent on admission, the resident should remain continent unless there's a medical reason that the resident becomes incontinent. So that's an important point from the original language of the law that has now been incorporated into urinary incontinence. As before, the regulation says if the resident is incontinent on admission, the resident must receive treatment and services to prevent urinary tract infections and to restore continence to the extent that that is possible. And also, as before, catheterization should not be done unless it's medically necessary. The new language in this subsection says that facilities must provide treatment and services to restore as much normal bowel function as possible. Fecal incontinence was never discussed before in the regulations. Next slide, please. This subsection combines what had been two separate subsections in quality of care, nutrition and hydration. And as before, a resident is supposed to maintain acceptable parameters of nutritional status, such as body weight, unless the resident's clinical condition makes this impossible. The resident is supposed to provide sufficient fluids and not just offer, is supposed to offer sufficient fluids, not just provide them, and offer a therapeutic diet as well. This is a change that CMS considers very significant for fluids and therapeutic diets, that they must be provided. The old language said fluids and therapeutic diets had to be offered. CMS says it made this change from offering to providing, and that reflects two important points. First, residents have the right to refuse, although CMS is clear that even if a resident refuses a therapeutic diet, the facility still must make sure that the resident's nutritional needs are met. But secondly, CMS is concerned in the preamble that facilities might, for example, just put water in a resident's room, but they don't make sure that the resident can reach the water pitcher and actually drink it. So the resident has to be offered fluids and assisted in drinking them if the resident needs. CMS considers this a substantial change and improvement to make sure that residents are hydrated. The facility has to offer a therapeutic diet when ordered by a healthcare provider, and for enteral feeding, which the old rules called nasogastric tubes, the rules now say if a resident cannot eat alone or with assistance, then enteral feeding must be clinically indicated and the resident must consent to the enteral feeding. The facility must try to restore oral eating skills if possible and prevent complications from enteral feeding if that's required and consented to by the resident. Next slide, please. There are several themes I just want to talk about that come up in these quality of care regulations, especially the new provisions, and we need to use these in advocacy for higher quality of care for residents. The first is the requirement that care be provided consistent with professional standards of practice. I think this is an important language that we need to rely on and reject any argument from a facility that it has its own facility policy or its own corporate policy as the standard of care. The standard of care is what the professionals say it is, and that's an important provision for the quality of care themes. The second theme I think we see in this is language about providing care in accordance with physician orders. We haven't had that much focus on what the physicians say or physician involvement in nursing homes, and that's very important. And I just wanted to point out again in one of the residents' rights that residents do have the right to choose their own physician. So their physician is providing orders that the facility is supposed to follow. Next slide, please. The third theme is that care has to be provided in accordance with the comprehensive person-centered care plan. And as I mentioned earlier, care planning is very critical. It is viewed as the facility's statement about how it must, what kinds of services and what it has to do in order to meet the resident's needs. And if the facility doesn't follow its care plan, if there's any decline in the resident, then that decline is not unavoidable. The fourth and final theme in these quality of care regulations that you'll see as we go through the next ones in particular is that care has to be provided in accordance with the resident's goals and preferences. So this is an important recognition that what the resident wants matters. Has to be professionally provided, has to be ordered by the physician, it has to be done in accordance with the care plan, but it also has to be what the resident wants. So I think these are extremely important themes that we haven't seen before in the regulations. Next slide, please. These themes appear in various subsections, and especially in the subsections that used to be identified in the prior regulations as subcategories of special needs. Special needs just listed various services like parenteral fluids and said nothing else about them. These have now been taken out of special needs and put into their own subsections with this kind of language, that if these fluids are administered, they must be consistent with professional standards of practice, physician orders, person-centered care, and residents' goals and preferences. It says nothing more about how these fluids are done, but those four standards are critical. Next slide, please. Similarly, with respiratory care, which was also formerly listed under special needs, the care has to be consistent with professional standards of practice, physician orders, person-centered care, residents' goals. Respiratory care, people may remember, was also discussed in rehabilitation services that we discussed in an earlier webinar. The regulation does not identify which types of respiratory care must be provided, so it's not explicit that all facilities must provide ventilators, but CMS was very clear in the discussion of rehabilitation services that states have a broad obligation to provide all of the services that any individual resident needs. Next slide, please. Same pattern here with prostheses, the standard that facilities must provide them according to care standard, professional standards of practice, person-centered care, residents' goals, and preferences. The goal here is ensuring that the resident can wear and use the prosthesis. That language is very important. If a resident has a prosthetic device, the resident should be using it. It shouldn't be locked up in the closet or inaccessible or not available. We want people to have what they need and to be able to use what they need. Next slide, please. And this is yet another example of a provision that was taken out of special needs and put into its own category. Same standard. So in a lot of these areas, CMS just used the language that I consider these four themes and said it would provide additional information in surveyor guidance. So as that guidance comes out in the summer, it's important that people become aware of what's in there, because there could be more information about what the expectations are for facilities. Next slide, please. So now we're going to talk about a few things that are brand new subsections under the quality of care requirement of participation. The first is pain management, which is extremely significant because we know that pain is often underdiagnosed and undertreated, especially for residents who have dementia. We know there's research showing that people who have dementia are less likely to get pain medication than residents who have the same medical conditions but don't have dementia. So it is extremely important and very noteworthy that CMS has a new subsection here under quality of care about pain management. The facility must address residents' pain with the same themes that we've seen before. Next slide, please. The second new provision that we've never seen before is trauma-informed care. This means that the facility must ensure that residents receive culturally competent, trauma-informed care, again, consistent with professional standards of practice and so on. What CMS identifies in the preamble is Holocaust survivors and survivors of war, disasters, and other profound trauma that the facility needs to be sensitive to. But as I was working on the issue brief for this presentation today and the PowerPoint. I read a blog post by Penny Shaw that many people probably know as a resident from Massachusetts who's an incredible advocate at the national and state level for nursing home residents and people with disabilities. And her blog post talked about the trauma of admission for residents and different aspects of life in nursing homes that need to be addressed to prevent the trauma that residents otherwise experience. And I thought it was a fascinating blog post, and there's a link in the issue brief when you get that issue brief, and I really urge people to read it. What she talks about is making sure that people have some measure of choice and control over their lives, how important that is, especially at admission, well, all throughout a stay, because it is traumatic to move into a nursing home. She talks about a soothing and comfortable environment, being open to the outdoor world. It's a very good blog post, and I think we should be taking Penny's very broad view of trauma and what nursing homes have to do in order to reduce the trauma for all residents and not just the limited number of people that they've identified. This is the only provision that is not in effect now. It does not go into effect until November 28th, 2019. Next slide, please. The last new provision is about bed rails. This is also brand new, and the regulation is quite specific about what has to happen. The facility must use appropriate alternatives before considering bed rails, review the risks and benefits of using a bed rail with the resident and with the resident's representative, obtain informed consent prior to installing bed rails. This is the second time in the quality of care regulation that the term informed consent is specifically used and specifically required. The first time was with enteral feeding. And if the bed rail is going to be used and the resident has agreed to it, then the facility must ensure that the dimensions are appropriate for the resident. A change from the proposed rules saying that the resident should be appropriate for the bed rail. CMS realized that was not the way to word it. So now the dimensions of the bed rail has to be appropriate for the dimensions, that the dimensions are appropriate for the resident size and weight. And the facility must also follow the manufacturer's recommendations and specifications for installing and maintaining the bed rails. This is really a very important provision because we know how often people are injured and actually even strangled to death on the bed rails. It's can be very, very dangerous for people. So this is important, and people should make sure that all of these requirements are met before bed rails are used. Next slide, please. There are 5 subsections that were moved entirely from quality of care, and I've listed them here. Activities of daily living is now under quality of life. Unnecessary drugs and medication errors have both been moved to pharmacy services. Mental health and psychosocial functioning is in a new requirement that's called behavioral health services, and influenza and pneumococcal immunizations has been moved to infection control. Last slide for me. These are my final thoughts about the quality of care. I think we were pleased that CMS kept separate the requirements for quality of care and quality of life. Their original proposal was that these would be combined, and I know many of us objected to combining them, seeing them both as important and interrelated, of course, but the reform law was the first law ever to talk about quality of life in a healthcare system, and many of us thought it was important that it be kept as a separate requirement of participation to retain that emphasis. So CMS did that, and we were very pleased and appreciative for that. On the other hand, we were disappointed that CMS did not write specifically about dementia care. A number of commenters said there needs to be a requirement of participation under quality of care or somewhere about dementia. It's so prevalent. CMS said it believes that that's addressed during person-centered care, but it would continue to evaluate this issue and may address it in some future rulemaking. So Lori, back to you now and the questions.
Okay, Great. Alicia, let me just turn to you to let folks know that today is National Storytelling Day.
Thanks, Lori. So as Lori mentioned, today is National Storytelling Day. As members of Congress continue to consider a health care bill that would decrease funding for Medicaid, they need to hear why Medicaid is important to nursing home residents, other long-term care consumers, and their families. We have prepared questions to answer yourself or to guide someone else in an interview. In addition, if you submit a story, they can be written or recorded with video or audio. You can submit the story via email, file share, or mail. Please visit our website for interview questions and submission instructions. You'll see this link on the slide above. We are hoping to collect one story per state. You can view our story tracker map on our website and see if your state is represented. If it isn't, submit your Medicaid story today. And with that, I'll hand it back to Lori to moderate the Q&A.
Okay, thanks. And even if your state is reflected there, please still submit your stories because we still do want them. So we've gotten a number of questions in on each of the different sections. Eric, would you maybe start by addressing the issue? There was a question about return if Medicaid is pending and if a facility can discharge a resident or whether they have the right to return to the facility pending Medicaid, pending a Medicaid application.
Right, so the question is, is the person Medicaid eligible if Medicaid isn't approved at that point? And I have to say that I think that's a tough call. I think the people, maybe others on the phone call would have more optimistic advice. I don't think it's specified one way or the other. You just, the language of the regulation says if you're eligible for Medicaid reimbursement, you have a right to return to the facility under that provision. There's no detail beyond that, no particular authority that I know of, and so I think it's worth an argument, but it's not a slam dunk.
Mm-hmm. Okay.
This is Toby. Lori, could I just ask a question? In the non-payment situation, that's one of the permissible reasons for non-payment, for discharge, transfer and discharge. But if a Medicaid application is pending, does CMS say that would make it not possible to transfer discharge somebody for non-payment when Medicaid is pending?
Yeah, I mean that's a good point. There's a provision in the regs now that it says that it's not grounds for non-payment if you have a pending application. So that's a good point, Toby. That's something to cite, that the discussion of non-payment under the transfer discharge regs says that and does not include people who have something pending.
Mm-hmm. Thanks, Eric. There were a couple questions about what to do if residents won't attend a resident council meeting because the staff is running the meeting and taking notes, or whether that's a concern. And certainly we hear that a lot, that's a big problem, that staff are really running the resident council meetings and residents feel that they don't have the ability to take control of the council. And so I would encourage the ombudsman to work with the resident councils in those scenarios. Ombudsmen certainly also have a responsibility through their requirements to provide support to resident councils, and that's certainly one way that they can provide assistance, is to help empower the residents to figure out what they want the structure of their council to be and how they want the staff to be involved. So and certainly residents need the information about knowing that they have the right to run the councils themselves. Eric, were there any other questions that you saw that you wanted to take a stab at? And I'll look for one for Toby too. We're a little bit over, but maybe we can do one or two more questions.
Oh, yeah, here's one on the return to facility. is how do you prove that there was an expectation of returning to the facility? I think that that has to be just based on the residents say so. And saying I want to come back, and that should be enough evidence that they expected to go back. Sure, I can imagine a facility saying, no, you don't have this right because we know you didn't have such an expectation. You can imagine the facility making that argument. It's a very cynical argument, and it involves reading the resident's mind and concluding that the resident, when he or she left, didn't have any intention to go back. But again, as a practical matter, I would hope that that would not be a limitation. And if a facility tried to say something like that, and take away the right to return, the resident, the family, the advocate, whomever would have to kick and scream and argue and explain why that doesn't make any sense and why allowing that might gut the regulation.
Mm-hmm. Great. There were some questions, and Toby, maybe you gleaned this from the regulations in terms of choice of physician and whether there are any requirements related to an advanced practice nurse.
I'm not sure what I think that's probably depends upon state law about advanced practice nurse, but I'm not sure. I think the choice of physician is always a difficult issue because usually people have the facility physician. That's often the medical director who becomes the physician for many of the residents. But residents do have the right to have their own primary care physician if the resident wants that physician and the physician is willing to come into the facility. And I think we should be encouraging that more, maybe, because person knows the resident better, and if the physician is willing to do it, I think that would be a good thing for residents to have their own doctor.
Mm-hmm. The other thing from the physician service, I think this is on point, pointing out that orders can be issued by a physician assistant, a nurse practitioner, a clinical nurse specialist under the regs. I don't know if that's exactly the same terminology of the question, but there's an effort to be a little bit broader in authorizing orders from those folks, and also allowing delegation to dietitians, for example, on dietary matters, or delegation to therapists on therapy-related matters.
Mm-hmm. Absolutely. And I think we can do one more question, and this has been a long time standing question, but one that has come in is whether bed rails are still considered to be restraints.
Well, has anybody looked at the restraint part recently? I mean, I was focusing on the quality of care regulations where they're addressed, although why they're under care is a little bit strange. I don't know the answer to that. Does anybody else?
I mean, this would be my sense. My sense from the regulations that the regulations were maybe a little, not necessarily like giving this answer, but a little more receptive towards bed rails rather than the previous regulations. So I would say that they're less likely treated as automatically as restraints, because I think the language talks more about clinical appropriateness, for example, as opposed to a presumption that they're dangerous from the get-go.
Yeah. It's just there's more protection about them, and there's quite a bit that has to happen before they can be used. So I think that's where we should put energy.
Right. And certainly, it's the purpose for which they're used. Are they there as an enabler to help the resident get up and get out of bed, or are they there being used to help to prevent them from getting out of bed? I think that also is an indicator of when it's used. So we're way over time today. There were lots of questions, and you can certainly email any of us to provide some direct answers. The webinar, this webinar, as well as the others that are part of this series, are on the Consumer Voices website and are available for download. you can do that at any time. They live on the website. And please reach out to us if you have questions. Thank you for joining us today, and have a good rest of the afternoon. Thanks to Toby and Eric for your continued work on this and for participating today.
Thank you.